All right. Good morning, everyone. Morning, afternoon, evening, depending on your time zone. And thank you for joining us for this Control J Alliance Global South Media Briefing. Protocol Indonesia, Understanding a Global South Proposal on AI Licensing and Digital Copyright. And my name is Sita. I'll be moderating today's media briefing. So, as I'm giving you a bit of a background, in late 2025, Indonesia put forward a formal position at the World Intellectual Property Organization, often referred to as Protocol Indonesia. It challenges the unrestricted use of copyrighted works by AI and reasserts the importance of licensing, including for news and other public interest content. And today we'll hear from speakers representing key countries in the Global South, Indonesia, Brazil, and South Africa. While we'll start with the Indonesian protocol, our panelists will also reflect on related proposals and campaigns in Brazil and South Africa, touching on broader debates around digital copyright, tensions between platforms, AI developers, and content producers, and what all of this means for the public interest. I'm also letting you know that we're also live on AMSI's official YouTube channel. And today's session will be structured as follows. We'll run for 90 minutes in total. Each speaker will present for around 10 minutes, followed by a Q&A session, so we have plenty of time for your questions. And our keynote speaker is Andri Indradi, Head of Legal Policy Strategy at Indonesia's Ministry of Law, who will walk us through Protocol Indonesia, its legal basis, scope, and current status within WIPO processes. We're also joined by an excellent panel. From Brazil, we have Vitor Ido, a law professor at the University of Sao Paulo, specializing in intellectual property and international legal policy. From South Africa, we have Michael Markovits, an adjunct faculty member at the Garden Institute of Business Science in Johannesburg, and director of the Gibbs Media Leadership think tank with over 2 decades of experience in the media, technology, and entertainment sectors. And finally, we have Indri Saptaningrum, a law lecturer at Atmajaya University and also a member of the Indonesia's Publishers' Rights Committee. But before we begin the session, I'd like to invite Mr. Wahyu Diatmika, the chairman of Indonesia Cyber Media Association, to deliver his opening remarks.
Thank you, Mbak Sita. Terima kasih. Distinguished speakers, colleagues, journalists, editor, researchers, all participants joining us today from Indonesia, Brazil, South Africa, any other regions, welcome. And good afternoon from Jakarta. Selamat sore. Assalamualaikum warahmatullahi wabarakatuh. Salam, Om Swastiastu, Namo Buddhaya, salam kebajikan untuk kita semua. Good morning to our colleague from Brazil and good day to our colleague from South Africa. On behalf of AMSI, I would like to formally welcome you to this Global South Media Briefing, Understanding Protocol Indonesia and Global South Proposal on AI Licensing and Digital Copyrights. First of all, I would like to say my thanks to our colleague at Control J Alliance for supporting this discussion. Momentum, Journalist and Tech Task Force from Brazil, our colleague Paula Miraglia, and Esther, and also the Gordon Institute of Business Science through the Media Leadership think tank in South Africa, Michael Markowitz and UMPA, and also, of course, the International Fund for Public Interest Media, IFPIM. We also appreciate the presence of participants from different countries in today's discussion. Allow me to also welcome our keynote speaker, Bapak Andri Indradi, Head of Legal Policy Strategy Agency at Indonesian Ministry of Law. This is the second or third even speaking invitation that Pak Andri has given to AMSI, and we are really grateful for Pak Andri's availability and always insightful insight and perspective about the current issues that we are discussing. And also thank you for Vitor Ido, Professor of Commercial Law at Sao Paulo University, Michael, again, the Director of Media Leadership Think Tank at Gibbs, Ibu Indri Saptaningrum, Lecturer at Faculty of Law at Bahasa University, and Ibu Sita Dewi, of course, AMSI board member, and also a PhD candidate at the Australian National University who will moderate today's discussion. The topic of AI, of course, is not only a technological issue. AI has now reshaped how our information is created, distributed, summarized, and consumed. And of course, we all understand that journalism and media are one of the most affected sectors of this disruption. But of course, we know as well that AI technology bring many opportunities. It can bring newsroom efficiency in terms of translation, research, data analysis, and bring new storytelling formats. But at the same time, AI is also raised many challenging and complex legal, economic, ethical, and policy questions. The first and foremost questions is who owns journalistic content when it is used to train AI models? How should us, publishers, be compensated when our reporting is being scrapped, summarized, or redistributed through the AI platform? And how can copyright law protect public interest journalism without restricting public access to knowledge? In this context, of course, we at the Global South countries want to participate meaningfully in setting the rules for the AI economy and not just consuming and accepting rules that are designed elsewhere in the world. In the Global South, the challenge is structural. AI platforms increasingly sit between audience and publishers. Search is becoming answer-based, summarized, no longer give us true, and with that goes the impression business model. Audience now receive summaries without having to visit the original source. AI crawlers only extract value from journalism, while we as publishers have to continue to bear the cost of reporting, editing, verification, and all the legal risk and digital infrastructure. Of course, this is a challenge for sustainable business model for journalism. Here in Indonesia, AMSI has worked with Monash University and PR2 Media, two of our research partners, to show and to find out how publishers are facing and coping with declining traffic, weaker referral flows, and increasing uncertainty about the future of journalism. And at the same time, many of our own members, small and independent media houses, still lack the technology, the technical, legal, and commercial capacity to protect and monetize content in the AI era. So that's why we think that AI licensing and digital copyright is not only a legal debate, it's about the future of journalism as public good. It's about media sustainability, information integrity, fair competition, and also democratic accountability. This is an issue that many countries are discussing, the impact of AI for copyright, regulation, platform accountability, and long-term sustainability of the media. And that's why Indonesia's recent proposal at the WIPO, the World Intellectual Property Organization, has become a very important part of this conversation. And of course, we know sometimes regulation moves slower than technology. Complex topics are sometimes oversimplified. Sometimes legal proposals are easily framed too narrowly. And so that's why we believe that this media briefing can give clarity and context so that all reportings around this topic can be more informed to allow meaningful conversation in the public. So that's the purpose of today's webinar. And we hope that the Protocol Indonesia can be clearly explained by Pak Andri and can be responded by the other panelists as a new initiative introduced by the Indonesian government. We also hope to learn from Brazil and South Africa, where similar debates are also developing in their own national context, because that's where we can learn and also share good practices, best practices for our context in Indonesia. For AMSI, this cross-country conversation is also important because Indonesia share very important characteristic with Brazil and South Africa. The three of our countries are large democracy with large markets. We have vibrant and also at the same time financially pressure media ecosystem. But at the same time, we also have strong civil society tradition. We have major user base that global platforms are depending on, but we all face asymmetrical bargaining power in relation to global technological platforms. So that's why we believe that this Global South cooperation is essential. We believe no single publishers can solve this alone. No single country can fully rebalance the system alone. We need to work together. We need to collaborate. We need to share evidence, common principle, interoperable policy ideas, and a stronger collective bargaining capacity. For us, the future framework, any future framework, should be guided by at least 4 principles. First, journalistic content has economic value. Verified reporting, public interest stories, local knowledge, archive, editorial judgment cannot be treated as free, raw material for AI system. Second, licensing mechanism must be fair and collective where necessary. We don't want to only benefit large publishers. Third, transparency is essential. Publishers, journalists, regulators, and the public need to understand how content is accessed, used, attributed, ranked, summarized, or monetized by any kind of AI platform. And fourth, regulation, any kind of governance must protect human rights. AI governance must not become an instrument of censorship or state control. It must protect press freedom, editorial independence, privacy, freedom of expression, and access to reliable information. Of course, today's discussion will not answer all the questions, but of course, we hope that this discussion can help us build a more informed foundation for any future debate. I invite all participants to involve actively in this discussion, ask questions, and bring your own perspective, because we believe this issue is very important to all of us. I think that's all from me, and welcome again to this webinar. I hand it over back to Mbak Sita. Thank you.
Thank you so much, Wahyu, for delivering such important keywords for the discussion: collaboration, just transparency, and also human rights. Now, without further ado, I'd like to invite Mr. Andri Indradi to deliver his keynote address. Andri Indradi is an experienced public policy and legal specialist with a strong background in government administration. He has expertise in network administration, research, public and private international law, management, and leadership. He holds a PhD in public policy and international law from Flinders University, Australia, and has built a career contributing to legal and policy development within the public sector, including roles related to Indonesia's Ministry of Law and Human Rights. Now he is serving as head of legal policy strategy agency. So to start us off, Mr. Andri, could you walk us through Protocol Indonesia in clear terms? What exactly is being proposed and what problem is it trying to address? The floor is yours, Mr. Andri.
All right. Thank you very much, Mbak Sita, and also a very warm welcome to all speakers, and of course my colleague here as the organizer, Pak Wahyu Jatmika from AMSI. My warm welcome to Mr. Peter and Indri, and also Michael from South Africa. So very good afternoon for Indonesia, good evening, and good morning for our colleague in Brazil. I'm very delighted to see all of you today, although we are seeing each other in Zoom, but this is a very good chance for me to know you better and to understand how our Global South perspective to see the issue of copyright, especially in terms of journalistic works. So again, ladies and gentlemen, and distinguished reporters, editors, newsroom researchers, and media advocates, especially from Indonesia, Brazil, South Africa, and across Global South, let me introduce again myself. My name is Andri Indradi. I'm serving as a Director General for Legal Policy Strategy Agency at the Ministry of Law of the Republic of Indonesia. And of course, we are gathered here today to engage in a very important event in building a constructive discussions on the future of digital economy, the governance of intellectual property, and the survival of public interest journalism in the age of artificial intelligence. We are in a meeting as a direct continuity of dialogues that initiated by Control J in Kuala Lumpur international event in November 2025. So some of you I already met before. Wahyu, of course, my good colleague from Indonesia, and Michael from South Africa, and other colleagues as well. The Kuala Lumpur event actually has laid the essential groundwork for global conversations. Afterwards, we subsequently advanced the conversations at the Media Sustainability Forum in Jakarta on December 4th, 2025, supported by the National Committee for Digital Platform Responsibility and the Indonesian Institute of Journalism. In Kuala Lumpur, I already presented the Indonesian proposals, what many of you in the media call it Jakarta Protocol. So let me now would like to reaffirm that we have changed the name of the proposals not to be Jakarta Protocol, but Jakarta Indonesian proposals for some reasons. Of course, because this issue has not been endorsed as a product of international treaty, so we have not yet used Indonesia Jakarta Protocol, but Indonesia proposal instead. So we formally propose a legally binding instrument at the WIPO, or the World Intellectual Property Organizations, focusing squarely on the governance of copyright royalty in the digital environment. At the initial stage, our objective was intentionally broad and sweeping. We observed that many countries in the global south suffer from severely underdeveloped legal infrastructures in the digital licensing space. We noted that the highly limited institutional capacity within our respective collective management organizations. We saw and continue to see widespread practices of digital usage without fair, transparent, and just compensation benefiting the actual creators and the right holders. Our initial intent was to create a unified global rules framework that would encompass all digital works. We sought to protect music, audiovisual content, and journalistic works under one comprehensive international copyright reform strategy. We argue that when journalistic content is republished, aggregated, or utilized in AI-generated contexts, it routinely passes through jurisdictions where right flows are fundamentally weak and entirely non-existent. We argue that global licensing metadata, digital identifiers, and right registries needed urgent standardization. Global licensing metadata, we believe that by doing so, newsrooms could gain the interoperability and feasibility required to improve their chances for fair remunerations in borderless digital ecosystems. However, public policy cannot afford to be static. The true legal strategy requires rigorous, continuous analysis, brutal honesty regarding institutional realities, and the courage to adapt when the empirical fact demand it. Today, I'm here to announce a fundamental shift in our strategy regarding the governance of media and data. Ladies and gentlemen, the landscape has shifted. Following extensive reviews and consultations with stakeholders and IP experts, we have reached a definitive conclusion. The Indonesia proposal, or what's so-called before the Jakarta Protocol, WIPO, will proceed. This initiative remains our primary vehicle for fairness and transparency in the digital ecosystem. However, to ensure its global viability, the proposal will now focus exclusively on musical works first. This shift, not a withdrawal of support for journalism, but rather a strategic calibration to ensure our legal tools align perfectly within the specific economic realities of different recreative sectors. Our long-term strategy for the press avoids categorizing news as a standalone entity, as it is not yet recognized as a treaty-protected subject in most international conventions. Instead, we advocate for protections of its constituent elements, audiovisual content, images, and literary texts, which are already firmly anchored in global IP frameworks. By leveraging these existing pillars, we can move effectively champion the exclusive rights of journalists and media professionals, providing them with protections analogies to those afforded to the music industry. Furthermore, it's imperative that we cultivate a robust royalty ecosystem for journalistic products to ensure long-term sustainability. This necessitates the establishment of comprehensive regulations and formations of specialized institutions for collections and distribution modeled after collective management organizations or CMOs. By developing this dedicated infrastructure, we are building a more precise, enforceable legal foundation for the future of Indonesian journalism on the global stage. We will discuss further these ideas in the next slides. To understand the disconnect, we must examine the foundation of international copyright law, the Berne Convention. The Berne Convention provides international protections for literary and artistic works. However, the legal status of news has been a subject of intense debate since the inceptions of global intellectual property frameworks. The harsh legal reality is that the international copyright norms frequently harbor exceptions for news of the day or miscellaneous facts having the character of mere items of press information. Furthermore, global copyright principles permit quotations from a work to be made available to the public, including quotations from newspapers articles and periodicals in the form of press summaries, provided it aligns with the concept of fair practice or fair use. As long as the source and author are cited, these press summaries often fall completely outside the realm of compensable copyright infringement. But the divergence between the music industry and journalism industry goes much deeper than the statutory definitions of literary works. It is rooted in the very economic and contractual structure of how these distinct works are created, owned, and distributed. Consider the contractual reality. A journalist, in most cases, is bound by an employment contract with a publisher or a media organization. The copyright of a news article typically belongs to the media company as a direct product of the employment relationship. In the stark contrast, a music artist or songwriter is bound by a licensing contract. In the music industry, the songwriter assigns the copyright in their unique compositions to a publisher specifically in exchange for a structured flow of royalties based on public performance or reproductions. Because journalists are generally tied to the employment contracts rather than the licensing contracts, the mechanism for tracking, distributing, and allocating compensations and remunerations are fundamentally different. Therefore, attempting to build a global royalty collections distribution framework, WIPO, that tracks daily news articles exactly like pop songs is quite a different and difficult strategy. It ignores the fundamental difference in the economic distribution of creative works. And it also entrenched the legal reality of fair use and fair dealing regarding the news of the day. If we consistently continue to push, at this stage, journalism through the traditional WIPO copyright track, we will fail. The global technology platforms and AI developers will simply point to established international convention, claim for fair use for their algorithmic news summaries, and continue to sip on the intrinsic value out of, of your newsroom without paying a single cent in remunerations. We need a new strategy, and we need fundamentally new legal tactics. To effectively protect journalism in the era of artificial intelligence, we must stop looking at the news merely as a copyright literature subject to centuries-old legal loopholes. We must start recognizing it for what truly is the modern digital economy, structured high-value data. We are currently witnessing a massive, unprecedented paradigm shift regarding the concept of data. In the past, data was widely viewed as a passive byproduct of an organization's primary activities. It was viewed as an exhaust fuel of commerce, something to be achieved, something to be archived, stored away, and used only if strictly needed for historical reference in the future. Today, that paradigm has shifted entirely. Data has transformed into an active, strategic, and profoundly crucial asset for any modern organizations. Data is the foundation currency of the digital environment. This dramatic transformation is driven, sustained, and exponentially accelerated by the rapid development of artificial intelligence. AI systems, particularly generative large language model or LLM require colossal amounts of data to train their algorithms, refine their outputs, and improve their operational quality. These generative AI systems rely directly and heavily on journalistic content. They require verified facts, the structured narrative, the linguistic precision, and contextual analysis produced by professional newsroom to function effectively. Because of this insatiable, relentless need for high-quality training data, technology platforms are utilizing massive amount of journalistic content without consent, without transparency, and without licenses. They are frequently resorting to scrapping what is effectively pirated content to build trillion-dollar commercial products. In developing nations across the global south, including Indonesia, Brazil, and the South Africa, the consequences of these uncompensated data extractions are devastating. Due to existing social, economic, technological, and institutional disparities, our media industries are highly vulnerable. The media industry is fundamentally an industry focused on the productions, processing, dissemination of data. And yet, our industries are not receiving economic benefits proportional to those in developed nations, while our data is being harvested at the exact same rate. The media industry, professional journalists, and the institution of journalism itself are essential pillars of democratic life and the national development. When the economic foundation of the media ecosystem collapses, due uncompensated data extractions, it leads to catastrophic chain reactions. Bad data pollutes the information space, bad economic bankrupts local institutions, and bad policy inevitably follows. Therefore, we must explicitly state that the problem is not just about missing fractional royalty check for a single news article. The problem is the systemic, uncompensated extraction of structured highly verified data by the global technology platforms operating without domestic accountability. So I would like to say again, the problem is the systemic, uncompensated, and the opaque extractions of structured, highly verified data by global technology platforms operating without domestic accountability. Since the international copyright framework at WIPO cannot adequately address these specific data extractions due to historical caveats, we must take sovereign responsibility. We must address it ourselves within our borders using our own authority. Although at the end of my presentation, I would also add something on that. Because the international rules and
Andri,
yes.
Andri, sorry to interrupt, but 2 more minutes.
Okay, all right.
Okay, sorry, thank you.
So I would like to maybe just go through the three pillars of domestic approach. So first is the redefinition of journalist output. The idea is to legally redefine journalistic output within our jurisdictions. And secondly, mandatory licensing and remuneration frameworks. The ideas envisage the establishment of strict mandatory licensing frameworks for the use of journalistic data by digital platforms. Third, algorithmic transparency. And also, next, regarding the CMOs, there are vital pillars to build domestic proposals. Is collective bargaining power. Why must it single specialized CMO? Let me outline the imperatives. One is, of course, the collective bargaining power, standardized remuneration and fair distribution, advanced technological tracking and auditing, and shielding against platform symmetry. So the last idea is a tactical advancement for global media, the reality, the strategic shift, the true stakes, and the final strategy. What we would like to say here that for the sake of the strategy, we would like to put music first at this first stage, while in our proposal, we are going to say there's an extension. There's an extension of the proposals that will be discussed once the issue had been honored. So we need ownership first from global societies. Once the ownership is gathered, we can now go into the extension issues that will cover journalism works as part of it. So Wahyu and also all other my colleagues, again, thank you very much for inviting Indonesia, especially the Ministry of Law of the Republic of Indonesia. It is a very occasion, a special event. We look forward for fruitful discussions, for insights to build the next SCCR that will be held in Geneva on the 15th until 21st of May. And of course, this strategy is for the sake of how we can get the ownership of the issue first, then we can move on to the next issue that will be more contentious and will be easier for us to move forward. I thank you very much for your kind attention.
Thank you so much, Pak Andri, for that presentation. What we're seeing here is clear attempt to push back against the default assumption that AI can freely extract value from copyrighted works. It also brings us into focus a wider question: who gets to set the terms of value and control in the digital economy? So to pick up on that, we'll now turn to how these debates are unfolding in other global South contexts. So I'd like to invite Vitor to share the Brazilian perspective. Vitor Pinto is a professor at University of Sao Paulo's Faculty of Law, where he has taught since 2024. He coordinates an international partnership program with French universities, and his research focuses on intellectual property, technological innovation, transnational business law, and interdisciplinary approaches to commercial law, including Global South perspective. So please, Vitor, the floor is yours.
Thank you. Thank you so much, everyone. So just counting my time here. So without further ado, I wanted to share a little bit of the Brazilian experience, but also enjoy the 6 years I spent in Geneva at WIPO, conducting some negotiations with Global South countries, and of course with Indonesia, terima kasih. So even was with Kawe yesterday, so our negotiator from Brazil, he sent also his regards. So let me enjoy that opportunity. It's a major honor for me to be here. I fully agree with the way this agenda has been set, and the way I wanted to frame my 10 minutes is to highlight a little bit how things have changed and how copyright has really changed in Brazil and Latin America, maybe from a focus on access to knowledge and open culture towards something related to controlling and taming market power, which really seems to be the core of the discussions related to journalism, as well as ascertaining sovereignty over big tech platforms from other countries. And in the case of Brazil, of course, this has been very important because of the Supreme Court fake news during misinformation during the past elections. And of course, this is the grander context that really applies to what we're discussing here. Secondly, I'll focus on a few initiatives, and I wanted to directly relate to what Mr. Andre was saying about Indonesia's proposal. And to do so, I'll focus on our AI draft bill, as well as some other legislative proposals, and in particular, a recent copyright and competition law case regarding journalism. And finally, I just wanted to share a few strategy points. Okay, so to set the tone, as I mentioned, I think it's important to say Brazil in the early 2000s was really spearheading the development agenda and really had this focus of transforming the IP system from within. And to a large extent, in the copyright realm at least, it all had to do with ensuring more access to culture, to knowledge, and there were concerns about market power of editorial platforms and some others. But as I already mentioned, what we're seeing right now is really a marked shift. We're also having a similar government from what we had in the early 2000s, but now the focus really has been on how the free knowledge and the free internet narrative was actually hijacked by big tech platforms and large transnational groups. And of course, in the case of journalism, considering that Brazil, just like, for instance, South Africa, enshrines pluralism in its constitution, including affording some special protection for indigenous peoples and other minoritarian groups, what we start seeing is how those platforms are using this open and free agenda in order to ascertain their market power. So I guess this is very, very important because it allows us to understand, already moving to analyzing some of the main points that I think will be useful for this conversation today, and specifically for the Brazilian perspective as of now. We had two main important processes. So first, we just had the approval of a new bill regulating the protection of children and teenagers online. And secondly, the Supreme Court ruled, very importantly, a major shift in the way it understands internet liability for not only internet service providers, but also generally how internet is regulated. And of course, this has been politicized in many different ways, but what I wanted to highlight here is simply the fact that there is ongoing concerns here on how the lack of regulation would lead to misinformation and direct harms to democracy. Of course, this also means that therefore the role of free, independent, democratic journalism is particularly important in the country as of now. But because of lack of direct funds, and of course, Brazil has always been, because of this, the military dictatorship's experience, has always been very reluctant on having public-owned or direct intervention in journalism. The way this has been regulated also means that we need to ensure new economic viability models for journalism. And then it gets us to what's going on currently. Enjoying the excellent presentation by Dr. Andre. Of course, in Brazil, what we have found out because of this competition law claim and investigation since last year is that we already see a very remarkable decrease in traffic, not only by big news platforms, but in particular for minoritarian groups. I think this data is very important to be highlighted because unlike general expectations, where maybe you would assume that, a platform that is working on Black-owned perspectives or focusing on indigenous groups or focusing on gender, maybe they would already have their niche. But what we're seeing is that actually the business model by Google, especially with the Google ads, and now with the AI overview, has actually very significantly decreased traffic and therefore revenue models for journalists. And if you tie this to what I just mentioned before, which is the need for stable and increased resources for journalism, what we see is really, and I don't want to exaggerate here, but I do feel that it really is a matter of ensuring democracy and the country. So let me start then looking at what our competition authority, known as CADI, has just done last week. So 5 years ago, this Google Ads case, meaning an investigation on anti-competitive practices conducted by Google related to the creation of snippets, so the summaries of the news, and I guess most of the audience here will know what I'm talking about, had been also launched in Brazil, but was actually archived back then. Because of this broader process that I've been mentioning, last year we saw the attempt to relaunch that investigation. Thursday last week, the competition authority decided to not only relaunch the investigation, but formally start an inquiry against Google, including AI. So this actually means that our competition authority is already looking not only at the reduced traffic to publishers, but the lack of an effective opt-out mechanism without which you're actually not allowed to mandate Google not to use your content for either the creation of snippets. And now we already have different models around the world, both on the financing side and on the way the Google algorithm can use. And of course, this means that for the first time in many years, our competition authority is looking at an anti-competitive conduct that is related to everything you can do to circumvent the implementation of copyright for journalists. This is, of course, an ongoing case, but I think this is very important for us to highlight, not only because of the direct consequences for Brazil, but because we are directly looking at the models that other countries such as South Africa have implemented in this case. Of course, this is accompanied as well by some private litigation. So our biggest newspaper, Folha de São Paulo, has launched a case against OpenAI that is very similar to what New York Times and Asahi Shimbun in Japan have done. And if you start looking at all the pieces I'm trying to bring to this discussion today, then we get to, and I wanted to focus a few minutes on the copyright provisions in our current draft of an AI bill. So there was a working group in Brazil that was attempting to create a general AI regulation bill. And of course, copyright has from the beginning been a very, very important point of concern. There was, in particular, at the very beginning, a discussion on the inclusion of a text and data mining exception, which would basically allow not only fair use or fair dealing, which don't really exist in Brazilian copyright law, but then they would directly enshrine the possibility of AI companies to harvest all content from journalists, as well as other forms of copyrighted content, of course, without any form of compensation and also without any form of prior authorization. The way it has been framed now has been limited to exclusively research purposes and non-commercial purposes. And of course, this has been met by strong discontent in particular big tech platforms. One particular point that I think is also very much related to Indonesia is the fact that Brazilian copyright creative industries are very strong. And this, of course, means that they're balancing out each other a little bit in terms of who wants to have their voice heard at the National Congress. I wanted also to address two other points of that bill without being too specific, but just because this relates to Indonesia's proposal at WIPO. One, related to algorithmic transparency, is the fact that the Brazilian government has proposed an obligation of transparency reports. And of course, this has always been met as something that is currently technically impossible, but the fact that it's impossible as of now does not mean that it's not that is not possible in abstract. And of course, it actually means that there's new business models that could be developed from that. So again, mentioning all of this, the AI bill has not been approved, but this means that the Brazilian experience is attempting to create a new regulation of copyright that enhances transparency mechanisms, as well, second point, the creation of an opt-out system that is different from the one that we see, for instance, at the EU level. At the EU level, you can opt out, but only subsequently, which actually means that in the AI realm, it doesn't really mean much. So what Brazilian government is trying to propose in that bill is to really create a new ecosystem that would be applicable to audiovisual, to music, as well as journalists, that would enable both transparency and remuneration and compensation schemes. Just wanted to very briefly, because otherwise I'm going to be speaking here forever, apologies for this, but just a couple of points on how courts have dealt with this. So very recently, we had an interesting case in Brazil where an amusement park decided to replace traditional songs by an AI-generated content. And they didn't want to pay any royalties for it because they said, well, that is purely AI. And what was interesting in that twist is that they were actually mandated to pay for the royalties, regardless of the fact of whether we would consider this to be copyrighted material or not. But this is also actually an equity mechanism if we think about the way it has been framed, because the point is that big tech platforms as of now are creating a whole business model whereby they can have access for free of all the data and the content, and then will simply argue that they must not remunerate or compensate or recognize anything at the output level. So I think to a certain extent, although this is not a journalism case, this one highlights to a novel interpretation whereby maybe you don't even need to consider that a copyrighted material, but it's really a matter of trying to equalize. If you're getting something for free in the input level, you should at least get some remuneration at the output level. I think that's important for us and in order to reflect on novel strategies. So just to finalize what I had to say about how all of this fits into WIPO's current work and Indonesia's proposal, I think Indonesia's proposal is very welcomed. GRULAC, so the Group of Latin American Caribbean Countries, has tried for the past few SCCRs trying to relaunch a discussion on copyright in the digital environment. And I think the proposition that Indonesia is bringing is very helpful because it allows us to move forward on more substantive terms. I just wanted to highlight, however, 2 points that I think are important for our collective strategic consideration here. The first one is that the WIPO landscape has changed when it comes to copyright. If you looked at the way it worked at WIPO 5 years ago, you had all the industries sitting together and you had all civil society sitting together. Now that's no longer the case because the industries have split because of AI. And similarly, this happened with civil society organizations. So some will continue to argue, let's make it all for free and leave it open, whereas others are now more concerned about the things we're discussing here as of now, including pluralism, including democracy. So I think that's important because that may have new strategic paths and avenues to work at WIPO. I'm not particularly sure that we're going to unfortunately reach a binding instrument so soon, but of course that spearheads a new chapter in this kind of conversation. And finally, I would just invite us to keep looking beyond WIPO, not looking at this disconnect. But I do think that what Dr. Andre was saying is very important in the sense that there's other fora that should continue to be explored. For instance, we recently had the approval of the Global Digital Compact that in many ways was also a missed opportunity in highlighting some of these data sovereignty concerns as well as opportunities to reflect on the copyright system. And similarly, if we look at some of the recent proposals and negotiations at UNESCO, including the guidelines for platform regulations that were recently adopted a couple of years ago. So I did have too much to say. I went already beyond my time. So I'm just going to be concluding by saying that this kind of conversation, Global South conversation, is particularly important in my view because it really allows our countries with our particularities, as was already said, to really think about how copyright is not dissociated from major concerns of democracy and pluralism. I'll stop there. Thank you so much. Terima kasih.
Thank you so much, Vitor, for that intervention, and for bringing out the marginalized concerns, and also you help situate these debates not only about legal doctrine, but also how different jurisdictions are grappling with governance of data, value, and also technological power in the digital economy. All right, now turning now to the African perspective, I'm pleased to invite Mr. Michael Markowitz. Michael is a faculty member at the Gordon Institute of Business Science in Johannesburg, South Africa, where he heads the Gibbs Media Leadership Think Tank, an independent platform focused on strengthening African media in support of democracy. He is widely regarded as one of South Africa's leading experts on media and technology policy. His career spans both academia and industry. He has held senior roles in public and private media institutions, including as special advisor to the chairperson of ICASA and as a senior executive at Prime Media, where he led digital businesses for 8 years. He also completed a 5-year term on the board of South African Broadcasting Corporations. Okay, Michael, the floor is yours.
Thank you, sir. Thank you so much. And let me echo the words of Vitor, and is to say I'm really honored to be part of this discussion. And, in a world where hope is absent on many issues, I think it always gives me great comfort to be sharing these issues with our colleagues, particularly in Brazil and Indonesia, but broadly in the global south, because I think this is a time for new alliances. In a very polarized world, we need to build on where we're sitting, which is our strength. And I'm very happy that the Control J Alliance have played a role in bringing us together, whether it's at the government level or the civil society level, and long may it continue. So I just wanted to say that from the outset. Secondly, before I kick off, my expertise, obviously, Vitor is very, very experienced in the WIPO environment, and I've really made some excellent points. I must also just say that Dr. Andrade's strategic shift was quite a welcome thing to hear, because as you'll see from my presentation, I kind of anticipated that something like that was necessary, but I hadn't realized that it actually had taken place. And when I look at the Indonesian proposal and the one that I was recently seeing, it surely has to be supported. And obviously I cannot speak for my government, but I would like to think that it would be supported by our partners, whether it's in BRICS or certainly in the global south. And I won't necessarily repeat what either Vitor or Dr. Andrade has said, but it clearly has identified some clear problems with the existing copyright framework globally. And I quite like the fact that it was building on the Latin America group, and back in the day, the African group, and trying to build a kind of global South position, which I think is very, very important. And even before I had a sense of the strategic shift, I think that the Indonesian proposal really recognized that different content sectors, including journalism, may not fit, but in fact does not fit really in existing royalty-based models. And, basically what we can see is that, a lot of the music industry, the film industry, and some of the authors, they're well established in copyright law. They're supported by these CMOs. And what the Indonesian proposal demonstrates is, yes, this is what they're intended to do. They're intended to collect royalties across markets, distribute value to rights holders, enable cross-border licensing. But the proposal highlights that clearly those issues, those systems for the existing copyright framework are under strain and need to be dealt with, and also try and include journalism in the thinking of how we approach. And I just wanted to see, yes, okay. So how we approach looking at value. And I think that what we've seen historically in the music and audiovisual sectors, we see that value is organized around licensing at scale. Very much a pre-AI, but the rights are structured to enable continued monetization. We've seen the markets, media, participation in market media, supposedly mediated through licensing frameworks and rights ownership structures. And essentially, these systems are meant to create a system where value can be tracked, monetized, and redistributed. Obviously, the critique from Indonesia, and I'm sure from Brazil and others, is that it's really about how well this existing system distribute values across the borders, not whether there's a system at all. So there is a system, we know that, but we're saying, A, it's not really fit for purpose in the AI world, but we're basing it on something that exists. When it comes to journalism, we don't have that, okay? And I think that's where I hear the Indonesian proposal, the departure point is. Because if you look at it, journalism has been outside the system of value collection. There's no CMOs for journalism. There's no system for licensing at scale, tracking usage, collecting royalties. And it's got a very good reason for that. Because journalism has been based essentially on advertising revenue for many, many years, probably a century. And it's looking at audience reach. So the whole business model of how journalism is financed has never really, and I stand corrected from my colleagues who know more than me in the copyright space, but I've never seen it base its revenue on copyright. There might be some syndication deals where you sell your content and you license it elsewhere, but it's certainly not based around royalties. And I think that would be a very important shift, because it's coming from a realization that the current business model is broken. There's a market failure. And therefore, we need to look at how do we protect our content in journalism from this very new situation where, in the last few years, and as I say, the structural implication is there's no embedded mechanism for journalism to capture value from downstream use and participate in cross-border royalty systems. And I very much hear that the start will obviously be how do we sort out the existing big audiovisual players like music, film, and television, and then create that pathway for journalism. I want to just, having said that really at the WIPO level and at the global level, just move into South Africa, where we are in a very interesting situation. Not ideal, but certainly we've made progress. And I think the three areas I'd like to talk about is obviously competition law, AI policy, and copyright. And I'll start off with the competition law, in which most people are very familiar about. I'm not going to go into all the remedies that the Competition Commission came, but I think from not just a global South point of view, I'd like to think from a global point of view, our Competition Commission has charted the way forward on how competition law can be used to first identify a problem through evidence gathering in markets, using markets and unfair competition as a major tool to then propose compensation mechanisms. And so they first had to have a market inquiry. And as you know, the big headlines was that, Google had to make a big compensation, but these were all negotiated settlements. And the reason why, and the chairman of the inquiry, James Rod, is very open about it. The reason why they just went for an approach of saying, let's negotiate settlements, is to avoid being in litigation for 5 years, and then the media industry gets nothing. So they took a very pragmatic view. They took 18 months. They got access to a lot of data, and I know the position of the Indonesian government, and I think Vito mentioned it as well, is without access to the information about how the content is being used on the platforms, without that transparency, it's very difficult to assess, what the value is and how the value is being extracted. So they were able to get a lot of information, but I just want to focus now on what they said about AI. And it is interesting to note, and the role of civil society is very important here. In the first terms of reference in 2023, there was no AI in the terms of reference. And because of civil society representations, we were able to get it included. And I think that was very important. What we were able to see that they did not go for a compensation regime. And it was very purposeful. they basically, what they got was enforceable negotiated remedies with AI companies, which included mechanisms of like helping publishers control opt-outs and engagement, and training and capacity support. Now, that's very, very limited in terms of the AI companies, but and obviously that left us without a framework for licensing of journalism content, which we've been talking about before, and there was no framework for compensation of AI training or downstream use. But their position was very, very deliberate, and I think that you'll find it in the report that AI markets they said are rapidly evolving and uncertain, and they felt that it was not appropriate at this stage to impose a compensation regime, not because they didn't think that there was no value. They explicitly found that there was a problem of value extraction from the AI companies. And I think that's a very important marker, because what you've had is a competition inquiry that found, yes, it does add value. If it didn't add value, they wouldn't be scraping it. Okay, so the question of the value, I think, is a settled point in this inquiry. But obviously, we don't have a mechanism at a certain statutory level to deal with that. Now, a bigger problem. A bigger problem is our Copyright Amendment Act is what I can call a site of political and corporate struggle. That act went through so many iterations. It was eventually agreed against the protests of the cultural industries, of the media industries, of performers. But it went through and it was sent to the president for signature. And the president, I'm cutting a long story short, there were also procedural concerns. A lot of the opposition parties raised procedural concerns with the Copyright Amendment Act. And it was referred to our constitutional court, because in our constitution, if the president has concerns whether a law might be constitutional or not, he can refer it to the constitutional court for a decision. And the issues were really the scope of fair use. I mean, I'd say that's the biggest thing. It's no coincidence that the tech platforms were incredibly happy with this act, okay? They wanted this. It broadened fair use. In fact, it would have given them a blank check to scrape up all of these of our content without any compensation. So it would have made where the Competition Commission ended purely academic if this thing actually becomes law. But the downside is, colleagues, is that currently in the competition frame upon which we're trying to base a lot of this discussion, in our domestic scenario, there's no legal certainty at the moment, and the limits of content use in digital environments and the scope of permissible data use. So what does this mean for the protection of journalism content via copyright in South Africa? There is no stable legal foundation for licensing at the moment, or asserting rights in new forms of content use. So one thing that I need to just say, and I think it's very important, is some of you might have noticed, and I think this should be a teachable moment, not just for governments, but for everyone, is last month our Ministry of of Communications and Digital Technologies released an draft AI policy paper. And it was revealed in the media last weekend that some of the references in this AI policy paper were actually fictitious and AI generated. Of course, hugely embarrassing. But what was good about the minister's reaction was he owned it. He immediately owned it, and he said, this is unacceptable. It totally shows what can happen when there's no human oversight over AI, and he withdrew the policy, okay? Now, the policy wasn't great anyway, but I think that it's probably an opportunity to have a reset. So what you have at the moment is the Competition Commission has sort of ended at a particular point where they recognize the value. They made a finding on basically robot.txt and opt-outs. They said there is value, but there's no certainty in the copyright frame. And obviously, we don't yet have an AI policy, which is still under development. So no framework at the moment for licensing, compensation, and value sharing. So what are publishers doing? I think what they're doing is around the world, which is quite common. They're trying to use robot.txt and AI-related tagging, and we will be releasing a report hopefully soon that shows that about 30% of South African publishers are using robot.txt, which is quite a high percentage. We don't have as many publishers as Brazil and Indonesia, but I think it's quite important that they become aware that that is something they need to do. And I think, and Wahoo would know more about this than me, but there's emerging technical and market-based solutions. I mean, there are companies who are trying to play some kind of intermediary role, gatekeeper role, to see if they can sit in between journalism and the platforms. But these are partial and fragmented responses without a coherent policy or legislative basis. So I think for me, and I'd end off here quickly because I haven't been monitoring my times, and so if I've got more time, I'll take some later then, is to say that for me, the question in South Africa is no longer whether journalism has value for AI system. That has been settled by the Competition Commission, in my view. The question we are still left with is how that value is calculated and how that value is shared. And I'll end it off at that point. Thank you.
Thank you so much, Michael, for the very profound notes on the value of journalism. And I think our participants today resonate the most with that note. And also, I would like to remind the participants, all of journalists, colleagues, if you have any questions, sure, after the last speaker, we will move on to the Q&A. But if you want to type up your questions in the chat box, feel free to do so. Okay, last but not least, I'd like to invite Mbak Indri Saptaningrum, who will offer her reflections on the discussion so far, including some of the key takeaways, as well as the potential limitations and risks that need to be kept in view. So Indri holds a doctoral degree in law from UNSW Australia. Prior to joining Atmajaya University, she spent more than 15 years at ELSAM, a Jakarta-based human rights organization working on digital rights and rights-based internet governance. She was part of the early generation of civil society actors in Indonesia advocating for these issues. She is also a member of the drafting team of Indonesia's National AI Task Force, which is developing the National AI Roadmap for 2025, and currently serves as a vice chair of the Indonesia Publishers' Rights Committee. Mbak Indri, the time is yours.
Thank you, Mbak Sita. Time-wise, I will try to be straightforward to offer my reflections so that it will enable all the participants to have more time for question and answer. So let me just try to do this. So hopefully you can see this. So I have 3 points that I would like to talk. First of all, I would like to appreciate Dr. Indra's presentations. As we've heard from him, we see the progressions of the concept from the first time we heard in Kuala Lumpur, for example, with the notions of Jakarta Protocol into Jakarta Proposals. And from that, we see the progressings of the concept as well as that reflect also the responsiveness to see the dynamic at the WIPO level and the extent to which those proposals can actually get and obtain support from other countries. So that's the first thing that I think is very important, and we welcome that and we support that from the committee. I'm speaking on behalf of the committee at the moment. And then from the insight, the comparative insight from 2 countries, I would like to also offer my insight to not try to diverting the attention from the WIPO, but as Michael as well as Vito said, it is also interesting to see the local dynamic and the extent to which they can strengthen each other. So in that sense, I would like to offer the insight from what we experience in Indonesia, because we see we see the line of some sort of like similarities from the national perspective of what happened in Brazil and South Africa. There are two uptake that I would like to see is also happening in Indonesia. First, from both speaker, looking into the national context, we see that there is an increase in interest of the government of both countries to recognize the asymmetric power of digital platform and the lack of existing regulations that are actually able to uphold the governance of digital platforms as to ensure that the market is healthy enough for other players. So I believe in Indonesia, that's also the reason behind the establishment of the committee. We call it KTP 2JB that is responsible and mandated to oversight the platform contribution to promote quality journalism in the countries. Based on the recognition that there is an asymmetric power between digital platform and the media industries and the media players. So that's one thing that I see also shared by Indonesia. Aside from that, we also see that similarities in which the government try to also do a multi-track approach in trying to govern the digital platform. I believe this coming from the idea that no single regulatory approach will work to actually govern the digital platform. We saw that earlier before this few landmark decision from the Constitutional Court actually strengthening the liability of digital platform to also responsible in the distribution, protecting the distributions of the copyright materials. This is the case and decision issued in 2023. We also see that reflecting from the work of the committee, we see that because of the lack of regulations that can effectively address the accountability of digital platform, we see the level of compliance of digital platform to the presidential regulation is very low. This is explicitly mentioned in committee recommendation to the Ministry of Communication and Digital in early 2026. And we also highlighted that this environment is also contribute in the persistent what we call B2B trap, in which under this B2B some sort of like scheme, the asymmetric relation is actually being prevented from the committee oversight based on the NDI between both parties, and again highlighting the voluntary based principle underlying the B2B. And because of that, the committee failed to actually put forward recommendations and failed to function properly in exercising its oversight roles to actually put forward the agenda in questioning the adequacy and the fairness of the cooperation between digital platform and the media. And that's actually part of the core structural issues that plug the relation between media and the platform, digital platform at the moment. And the situation I think from that view, the situation is again worsening simply because AI then become the on variable in the existing B2B cooperation between digital platform and the media. And because of that, in some cases, the media seems to be put under the situation of not have an opt-out positions, an equal, kind of like bargaining power to say that I do not want to this and I want this one only. Because the threat is either you take it or leave it. If you don't take it in as an add-on, then you cannot have the cooperations. And again, because of the lack of regulations to support the functions of the committee, it's still a situation that we cannot actually exercise our institutional mandate to. And if we look into the landscape of AI adoptions, you can see that some of the perils of the promise of the AI adoption for media industry is already taking place, as Pak Wahyudiatmika, few weeks ago said that now we are continuing to see what we call zero click, search incidents or numbers in which AI based search facilities introduced by platform is actually hindering user from having an interest to go directly into the source and stop into that and being enjoyed by the ability to have a summarized and tailor-made summary for a particular user. So aside from that, we also see that the big drawback coming from the bias hallucinations and error coming from the adoptions of the AI in the newsroom. So because of that, despite the fact that actually AI is very popular within the day-to-day journalist work at the moment, the recent kind of like survey from BBC Action Media Report also highlighted this situation, or with the highlight note that despite the fact that AI is very popular, it does not relate to strengthen, to strengthen the actions against misinformation and disinformation, or even use it for fact checking, some sort of like tools and work. So with that, what I would like to offer to complement the previous two speaker is, first of all, we believe in the committee that there is an other strategy rather than a multi-track, policy reform, which comprises of, supporting some sort of like initiative introduced by Jakarta Protocol, although we realize that it did not and choose not to include, some sort of like explicit mentions and cover on journalistic work. But we believe that it will pave the way to open up and to strengthen the accountability and the regulations addressing the asymmetric power of digital platform. So based on that, we also believe that it should be complement with other reform at the national level. At the moment, Indonesia is actually in the process of amending the copyright law, in which some of us, including the committee, put forward the recommendations that there should be specific clauses that first recognize journalistic work as part of the protection within this new amended law. And as I said before, the presidential regulations number 32 is actually set out the foundational legal framework to actually shifting the paradigm from, some sort of like non-subject into copyright regime into subjected into copyright regime. And as well as, in line with that, the decision from the Constitutional Court in extending the liability in the protections of copyright distribution material on the digital platform is also in line with this some sort of like foundations that we believe should be considered to again help shifting also the paradigm in the new copyright law to also include and consider news product or journalistic work as part of or within the jurisdiction of copyright law, the new copyright law. And then because of that, the recognition also implies that the utilization of it, regardless the form of utilization, it can be scrapping for training the AI, large language model, or the aggregation of the news or other things, should actually be complied within the particular framework in recognizing the copyright of those producing the material, and as well as with that also recognize the moral benefit as well as economic benefit coming out from that product. And because of that, the real challenge would be striking the balance and encouraging a shifting in paradigm, because we realize that without compromising the function of news and journalistic work, media as the fourth pillar of democracy within the Indonesian history, the changing in digital ecosystem should actually lead into the shifting in paradigm on how we see uh, the way the journalistic work actually being produced. And as Mas Wahyudiatmika said, we cannot sustain and maintain the sustainability of the media without recognizing them as an economic entity that producing that. So in this regard, I think the challenge would be how would the clauses within the new copyright can strike the balance between the interests of the public and the recognitions of news and journalistic product as an important piece of work that require protection under the copyright, through which we recognize media has a morality benefit as well as economic benefit from their work. I think that's in a nutshell things I can over to also enrich the discussions, and we look forward for question and answer from the floor. Thank you.
Thank you so much, Mbak Indri, for the final reflection. And now we can move on to the Q&A session. There are two questions in the chat box already, and for colleagues who have question and would like to address it directly, you can push the raise hand button, and I will pick you for the next question. So the first question is from Vinop from Cambodian Journalist Alliance Association. The question is, I'm wondering if you were to reach agreements with AI development companies, what kinds of value sharing arrangement or best practices are currently being discussed or implemented? Vinop, do you have a specific panelist in your mind, or?
Thank you. Actually, it for the speaker who saw that the idea that we share. I really appreciate it. Yeah, I do not refers to any speaker, but of course to the speaker, to all panelists.
I'm sorry, V, you're kind of breaking up from here.
Do you hear me now?
Yes, yes.
Okay, thank you so much. Yeah, I'm really appreciate for all panelists who been sharing very value and also knowledgeable of experience, and also the ideas to be advocate with the AI's developing company actually. I really appreciate it. All panelists can share from the practice or the idea
Okay,
that
sure.
would be used to continue advocating by
Okay.
the media company with the AI developing company.
Okay, so it can be any panelist.
For sure, yeah.
Sure. Okay. Right. Okay. Michael and Vitor, would you answer the questions? Okay, Vitor.
Sorry, and usually people don't volunteer. It's just that I really need to disconnect in a few minutes because I have a
Okay.
flight in 5 minutes. No, but I just wanted to highlight. I think that the questions are very interesting because we do see in the audiovisual and the music industries new forms of, some would call collaboration. I would call it a little bit differently. I would say just an accommodation after pressure, sufficient pressure on AI firms to really force them to engage with new licensing models. I do think that can be an avenue to be explored. But because of the political dimension of journalism, and in a country like Brazil, because of the direct clashes between the main AI providers related to journalism and the very public interest purpose of the activity, I do feel that while perhaps useful in terms of gathering economic benefits for small journalists, media outlets in particular, globally, I don't think that's a structural change. So that really means, in my view, that you really need to scale up and add all of the regulatory tools that have been discussed today. So that includes competition law, that includes different modalities of regulation, and including impeding those platforms from just expanding market and political power against our governments. So I think that's important because this is not to be too negative about these ideas, but I do feel that in the case of journalism, precisely because of the very public purpose of the activity, we do need a more urgent structural change. And I really need to disconnect. I just wanted to thank everyone. Sorry for taking the floor before. I'm really looking forward to continuing this conversation with you all. Thank you so much. I learned a lot.
Sure. Thank you so much, Victor, for today, and safe flights. Safe
Thank you so much.
travels.
Terima kasih. Bye.
Okay. Pak Andri or Mbak Indri or Michael, would you like to add to that? Otherwise, we can move on to the next questions.
I
Oh,
think
sorry. Yeah.
Vitor covered my points already. So happy to move on. Thanks.
Sure. Okay. Next questions is from Abigail from Indonesia. I work at an AI company as a legal corporate. I have a question for all three speakers. Should be four. While international copyright reform may take time, do you see collaborative licensing agreements between AI developers and copyright owners, not only in music but across other creative sectors, as a viable interim solution? And are there other faster or more scalable solutions we can pursue in the meantime?
Well, maybe I'll go first, and I think
Sure.
it might be very dependent on the territory, but I'm of the belief, and maybe because I'm a former regulator, I would say this, but I find without impending regulatory pressure and pending legislative pressure, whether globally or locally, AI companies, platform companies don't just come to the table and come with settlements. They normally do it because they can feel there's pressure. The problem with it is that they've only been doing it with big companies, big media companies. So you see them, and I'm talking about journalism now, like the sort of, Financial Times or various deals done with the Axel Springer Group in Germany. And on the music side, I'm not as familiar with it, but my feeling is that those sort of bilateral private deals where you don't know what the value is and they negotiated, they're not accessible to us. We don't know how they valued the content in particular. So into a viable interim solution, I think is some of these potential technical intermediaries that are able to maybe set up some kind of licensing system online. That I know Cloudflare was looking at something, excuse me, and others have been looking at it, but it's not an easy solution. I think the last thing I would say is collective action by media publishers. Media publishers and media outlets are not historically known for wanting to work together. You normally have your big publishers that do their own thing, and then the smaller publishers are left out of the negotiation. One thing is, I'll finish with this, in Denmark, we've seen an incredible unity, and they've now sued OpenAI because they're standing together as a media industry. I think that's something we need to look at as well.
Thank you, Michael. I hope that answers your questions, Abigail. The third question from Damar Juniarto, also a member of Publishers' Right Committee. After listening to resource persons, I would like to address that the problem not merely about economic unfairness and lack of regulations, but also lowering the political role of journalism. There is bigger problem, the domination, the colonization of digital space by platforms. So all the effort from Global South is to decolonize the digital. Oh, it's a statement rather than questions, and I think we can all agree on the tone set in today's webinar is quite unison in that sense. Another. Okay, so there's follow-up question. So the question to all panelists is, what do you think doing a South-to-South collaboration to fight digital decolonization will work better than a national effort? I think, yeah, we all have the same questions. So national effort, and I think Michael also has already mentioned about collective efforts. Who would like to start?
I think I can do, and then Michael will, Mas Wahyu as an active, kind of like actor in building up sort of collaborations from multi-stakeholder perspective can also jump in. Because we also believe the idea also behind this webinar is the idea that, first of all, doing an advocacy alone for such a big objective in decolonizing, or not even decolonizing, but to create a level playing field with digital platform is very difficult to be achieved alone. So that's why the idea why the South to South is coming into place, first of all, perhaps politically speaking, the South countries has more or less similar situation in regard to, the in dealing with big tech giant and digital platform, which is mostly coming from the North. Secondly, it is good to consider the situation in which we realize that despite the fact that most of digital platform dominating the digital space coming from the North, yet the biggest market is actually coming from the South countries. So in that regard, another ideas behind the South-to-South collaborations is actually to leverage the market power, because instead of being a passive and silent consumer, we can actually stood up together to see and to share the belief that we know that we share and the experience that we have to actually improve the negotiation level, by using our power as a market into something which is politically improving the positions in the negotiation table. I think that's one response to Pak Damar. So we need to be upright in the spirit in fighting for that, I believe. That's from me.
Thank you so much, Mbak Indi. Would you like to add to that, Michael or Pak Adri, maybe?
I'm fine.
Yes,
Okay.
thank you, Bu Sita. Just would like to add a little bit from my perspective. I think the term decolonizing on these particular points, I think is quite exaggerating in my personal point of view. So in terms of how the journalism works can adapt with current situation is how we can align ourselves into the global playing field. Now, at the moment, what we see is the dominance of digital platforms and also the big companies which use, one of them is AI, to produce any products to be consumed by the public. So what I mean here is that instead of having a mind of being decolonized, in my opinion, I think we should put ourselves into the same frequency, into the same aligning with their mindset to compete and also to be accepted as a product that can be remunerated and also at the end will be fairly compensated through our works. For example, I think at the moment we've seen now some of the journalist products adjust themselves to make their products to be accepted by the digital service platforms. There's so many podcasts, there's so many news products that have been accepted by the DSP and consumed by the public. And by doing so, they're entering the royalty ecosystems. Because Michael also pointed out correctly what I think is that the difficulty right now is how to value it, how to value the journalist's works. Now, the answer is we have to enter the ecosystem of royalty, the existing royalty itself. So by entering the DRM, what I call is digital rights management, the remuneration can be calculated because of the streaming, because of the consumptions, that can be remunerated to the authors or the creators of the news. So I think now, from my point of view, not as a bureaucrat, but as an academics, because what I like here to discuss as an academics, I think we have to align ourselves for our works to be accepted, to be remunerated, is to have the same playing the same products or the same shape as the digital service platforms had already managed through their digital rights management or DRM. So by doing so, I think instead of being decolonized, I think now the issue is how we can compete with other sectors in the copyrights ecosystem that can be remunerated with more transparency through the system of DRM. Although, as I mentioned, there's still homework to be done in the digital platform itself. But again, for the start, I think we should start thinking how we can make a product in line with the Berne conventions, in line with the existing copyright regime, law regime, that can be accepted, that can be remunerated, that can be managed through the existing ecosystem of royalty. So for those journalists who have their works can be remunerated fairly. Thank you.
Thank you so much, Pak Andri. And that will be our last notes for the session. I was already reminded that we're running out of time. Thank you to all our speakers for such rich and thought-provoking insights, and thank you to everyone for your engagement and questions today. We hope this discussion has offered a useful perspective and opened up further lines of reflection on collaboration, competition, and also, of course, marginalized concerns and human rights, and collaboration going forward. So we will now move on to the group photo session. I promise this will be the last bit for today, and I kindly invite all speakers to stay on for a moment. We'll guide you through the process shortly. Can you please turn on the camera for photo session? Mbak Tirta, would you be able to take the picture for us? Okay.
Of course, Kak. Okay,
Thank
in
you.
5
Thank you so
seconds.
much. Yeah.
We will have to use AI to put Vitor back in the picture.
Oh, that's right.
Okay. There is which one?
2 slides?
1, 2,
Yeah.
yes. 1, 2, 3. Okay, the next one. Wait for a second. 1, 2, 3. Thank you so much.
Thank you so much again for all the speakers and participants. See you again in other interesting sessions.
Thank you all. Thank you,
Thank
Mbak.
you.
Thank you.
Bye.
Thank
Thank
you.
you.
Thank you
See you
all.
all.
Thank you, Vitor.
Thank
To
you.
Thank you,
leave.
Bye-bye.
Thank you,
Bye.
Victor,
Michel,
Michael,
Michel.
Pak Andri, and Mbak
Thank you
Indri.
all.
Thank you so much.
Terima kasih, Pak.
Bye-bye.
Kak Novia.